I am Dr. Rajaram, retired professor of Forensic Medicine, Medical College, Thrissur. The idea of organizing a webinar was initiated by Dr. P. Sivashankara Pillai, former Director of Medical Education. He gave me the support in forming a webinar series talk. So, upon his initiative and encouragement, I started the preliminary work, and when the invitation was formed to be distributed among our group, I gave a name as Forensic Fraternity Kerala. So, when he came to see this, he said this is a very common name and we can give another name, and his suggestion was Searching Forensics. I found that very catching and told him that we will put this name. So, the name Searching Forensics was given, and he told me that we have decided to conduct at least 2 webinar, but it is better that you try to continue it so that it is helpful for other people. And I agreed, and today on the 21st of June 2020, we are going to conduct the first webinar, and the title is Medical Laws and Litigation Prevention. Dr. Padmakumar K., Professor of Forensic Medicine and Toxicology at Jubilee Mission Medical College, is going to render the talk, and Advocate Shyam Patman from Calicut is going to speak about the legal aspects, and the session is going to be chaired by Dr. Geeta O., Professor of Forensic Medicine and Toxicology at Gokulam Medical College. And I am going to introduce to you Dr. Padmakumar K. He obtained his graduation from Kasturba Medical College, Mangalore, and took his post graduation in Forensic Medicine and Toxicology from Trivandrum Medical College, and he took diploma in medical laws and ethics from National Law School, Bangalore, and he obtained DNB and fellowship in medical law and ethics from Indian Association of Medico Legal Experts. Dr. Geeta O., she graduated from Medical College, Trivandrum, and did her post graduation in Forensic Medicine and Toxicology from Medical College, Trivandrum. She did master in hospital administration, trained in pain and palliative medicine, and completed diploma in bioethics. She had her training in medical education technologies from Jipmer, Pondicherry, and done advanced course in MET from MCI. Advocate Shyam Patman is a versatile personality and very fluent in delivering speech. He is a corporate lawyer and techno-legal consultant practicing at the High Court of Kerala. He had his legal education from Government Law College, Calicut. He did his LLM in tax laws from Calicut University, and the post graduation in medical law and ethics from Law School at Bangalore. His firm, named Shyam Patman's Associates, has special reputation in conducting medical negligence and allied cases related to consumer disputes before the Consumer Protection Act, including the State and National Commission, New Delhi. He is the life member of the National Consumer Dispute Redressal Forum. He is also the legal counsel of the Bhavans Law College and National Institute of Technology, Kozhikode, in the High Court of Kerala. He is an adjunct professor in business law at the School of Management Studies, Vishwajyothi College of Engineering and Technology, Moovattupuzha. He is the lawyer of Indian Medical Association and Indian Dental Association for their professional protection schemes, Kerala. He gives professional service in the following field: general and civil law practice, Consumer Protection Act, cyber law, medical legal litigation, labor laws, corporate and commercial laws, intellectual property laws, real estate, and compliance audits. Over to Shyam Padman.
From its preamble, then DPSP, that is direct, then fundamental rights. So many things are there, so many sections are there, so many articles are there which deals with the health issues of our country. And the second most important health law in our country is the statutory laws. So the legislative, that is the parliament, passes a bill and it becomes a law. So that is called the statutory laws. And the third important laws are the common laws. So the common laws means these are the decisions of the court, various high courts and supreme courts, with the decisions taken by such courts.
Hello? Okay.
കോവിഡ്-19 ഇന്ന് നമ്മുടെ രാജ്യം മുഴുവൻ പോരാടുകയാണ്. പക്ഷേ ഒന്നോർക്കണം, നമ്മുടെ പോരാട്ടം രോഗത്തോടാണ്, രോഗികളോടല്ല. അവരോട് വിവേചനം പാടില്ല, അവർക്ക് വേണ്ടത് പരിചരണമാണ്. അതോടൊപ്പം ഈ രോഗത്തെ ചെറുത്തു തോൽപ്പിക്കുന്നതിൽ നമുക്ക് കവചങ്ങളായ നമ്മുടെ ഡോക്ടർമാർ, ആരോഗ്യ പ്രവർത്തകർ, ശുചീകരണ തൊഴിലാളികൾ, പോലീസ് തുടങ്ങിയവരോട് ആദരവ് പുലർത്താം. അവരോട് പൂർണ്ണമായി സഹകരിക്കാം. ഈ പോരാളികൾക്ക് നിങ്ങളുടെ കരുതൽ നൽകൂ. അങ്ങനെ കൊറോണ വൈറസിൽ നിന്നും രാജ്യത്തിന് മോചനം നൽകൂ. കൂടുതൽ വിവരങ്ങൾക്കായി നിങ്ങളുടെ ലോക്കൽ ഹെൽപ്പ് ലൈൻ നമ്പർ അല്ലെങ്കിൽ സെൻട്രൽ ഹെൽപ്പ് ലൈൻ നമ്പറായ 1075 വിളിക്കൂ. പൊതുജന താൽപര്യാർത്ഥം താങ്കൾ വിളിക്കുന്നത്.
Sir, I think it got stuck, sir. Padmakumar sir's video and presentation got stuck, sir.
വരുന്നില്ല കേട്ടോ.
സാർ, അപ്പൊ ഒരു കാര്യം ചെയ്താലോ, ശ്യാം പത്മന്റെ പ്രസന്റേഷൻ ചെയ്യാന്ന് പറയുന്നു.
എന്റെ അതായിരുന്നു സജഷൻ
അല്ലേ?
അതെ അതെ. Correct.
can start. Sham?
Yeah, I'm ready. No issue. By the time doctor can check his net connection.
Yes. You proceed.
You want to
സർ അങ്ങനെയാണെങ്കിൽ ഒന്ന് അത് മറ്റേ ഷെയറിങ്ങിന്റെ ഒന്ന് നോക്കുവോ?
ഷെയറിംഗ് പ്രസ് ചെയ്താൽ മതി, എനിക്ക് ഇത് വരും.
ശരി.
ആ, അലോ ചെയ്തു.
ഓക്കെ, താങ്ക് യു.
ദിനകരൻ,
Yes, I am listening.
നിങ്ങളെന്താ തലയിൽ തുണിയിട്ടിരിക്കുന്നത്?
തലയിൽ തുണിയിട്ടിരിക്കുന്നല്ല, ഞാനൊരു പ്രസന്റബിൾ സ്റ്റേജിലല്ല.
കാണുന്നുണ്ടോ?
കാണാം.
ഓക്കെ. So can I start?
Yes.
Yeah.
So leaders of the profession, thank you for this opportunity. It is wonderful to be with you in a fine Sunday morning. I'm sure that COVID and lockdown has its effect. That is why all of you are today in this fine Sunday morning doing nothing else than hearing a boring lecture from me on law. So I will start my presentation by the present scenario. There is a hostility going. The hostility is basically a blame game. We blame the courts, the judiciary, the judges, saying that the doctors are not being, or the medical profession is not being treated properly, or decisions are being rendered against them. Then if some decision is rendered against a doctor or a huge amount is awarded as compensation, immediately the first impulse is more or less like a spinal reflex, is to blame the court for having awarded such huge compensation. Today, I will try to demystify it and try to convince you that we are, in fact, the justice dispensation machinery and the professionals are on the same side, and there is no confrontation as such. And the Consumer Protection Act, new fora has come in, heavy compensation, no special consideration, etc. These are the things which I'll try to address, because the topic itself is avoidance of litigation. Now, I'll just put one question to you. What is the last thing you do? If others can mute, it will be better, so that there will be least of disturbance. Thank you. Am I audible?
Yes.
What is the last thing you do when you step out of the house? Now there is no question of stepping out of house. We are all confined to the house, but still, in the earlier time, which we thought was normal, we used to lock the door, right? What is so special about that door? Any person with reasonable strength can just break it open. But still, after locking the door, we have a sense of security, safety. We feel that our valuables, dear, near things kept inside would be safe. There is no magic in the door. The magic is in the legal regime in the country, which makes it punishable, unprofitable, or undesirable to trespass into someone else's property. That is the strength of the law.
Documentation.
A legal system in place, comfortable living or living at all may not be possible. So, before this August Assembly, I'll start my submission by saying that let us not feel that the law or the legal system or the justice dispensation machinery is not a threat or an uncomfortable thing, but it is a necessity, because that gives or that provides for an orderly life, or the safety, comforts, etc. that we are having. The very fact that we can go elsewhere, participate in seminars, and still be rest assured that we can go home. The home will be there, everything else will be there, etc. So instead of, and for that matter, I will also make one submission that we live in a country where rule of law prevails. It is not an individual, it is the rule or the law which prevails. So all of you, I am not taking you to the basics, but still, for the completion of my presentation, let us please understand the basics. The country, as we know, stands on three legs: the executive, the legislature, and the judiciary. Though not watertight compartments, they have their own roles to play. So once we understand what the roles are, these blame game and misunderstanding to a certain extent could be allied, or you can say that you can get over that. Legislature, as you all know, the primary duty is to legislate. They make the laws. Executive executes the law, executes the such orders, etc. Judiciary, it interprets the law and makes sure that the laws made by the legislature are within the constitutional framework. Not only that, they also safeguard the rights of the citizens if any of the rights are infringed or if they are in any way put to some harm. So first, let us understand how the courts decide. There has been a movement that doctors' cases should be dealt with by a body of doctors, engineers then by engineers, then we'll say lawyers by panel of lawyers, so that the experts in that field has to only decide a dispute. Would be a submission, was a submission that was being made earlier. Now we have an adversarial system of adjudication. Both parties are given liberty to put up their case, adduce evidence, substantiate their contentions, and of the both contentions, which is more probable, which is more acceptable under the existing legal regime, is translates in the form of a verdict. So I would say that the thought that it is better to have a professional be judged by his own peers is a fallacy, because that will create more problems. We may independently think of that, and during the interaction session, we'll also think about that. Because if my case is to be decided by a panel of lawyers, they'll have their own opinions, they'll have their own preconceived notions. We don't get an impartial adjudicatory process. Whereas the existing scenario, which is at par with any civilized country, is that the judge decides on the matters brought before it. He does not have his own convictions. He does not import that into that decision-making process. Of the two, which is more probable? Preponderance of probabilities. And how it is being decided? I can just draw a parallel. We have this card test available in the market to test pregnancy. All of you would be knowing about that. But still, put a couple of drops of urine at one end, you get one band, I think you're pregnant. 2 bands, you're not pregnant. 3 bands, I don't know what it is. But still, end of the day, if the card shows that band which says that it is indicative of pregnancy, will a doctor, if my urine shows that band, congratulate me and say that, okay, Sham, you are pregnant. Would you like to have a boy or a girl or something like that? No, because the medical science says that you all know this card only gauges a particular hormone. HCG, human chorionic gonadotrophin hormone. I think I am correct regarding that hormone. And the medical science says that pregnant women will have a heightened plateau of this particular hormone. So what about my urine? The same medical science says that if you have a malignant tumor, it would show the same results. So it is not the result, it is not the technology, or it is not what is brought before the doctor, but it is his forensic skill, his clinical findings, which has to be corroborated or correlated. Then and then alone, the doctor decides whether I should be taken to the labor room or I should be taken to a CAT scan or whatever scan necessary to identify whether I am having a malignant tumor or not. This is the same way in which adjudicatory process also takes place. The court swings and weighs the contentions, the materials placed by both parties, and corroborates it. His forensic skill will be used to evaluate these two, and finally a decision is rendered. And you are given the liberty, both parties are given the liberty to tender expert evidence, place authoritative textbooks, literature, and how it is being decided is that it all depends upon proper documentation, because the procedure that you have done, what you have carried out will be borne out from the document or the contemporaneous recording that is being kept, which can be said to be it can be even EMR or ordinary our case sheets. So this has to be placed before an expert.
ഹലോ അല്ല അഡ്വക്കേറ്റ് ശ്യാംപത്മൻ അത് കാരി ഔട്ട് ചെയ്തോ? ശരിയായോ? നെറ്റ് ശരിയായോ? ആ നിന്നുപോയി. അപ്പോൾ ഞാൻ 3 പ്രാവശ്യം വിളിച്ചു, അപ്പോഴൊന്നും കിട്ടിയില്ല, പത്മകുമാറിനെ കിട്ടിയില്ല. ഏതായാലും ജോയിൻ ചെയ്യും.
Can I continue? Yes. Thank you. So the quintessence of my submission regarding this is that if for all problems, if somebody comes into your property or somebody demolishes your compound wall, or if you got any other problem, legal issues, you approach a court of law. Then why not a patient? The patient, as far as we say, is a doctor or a professional. And for that matter, please understand, negligence, the definition, the way it is being gauged, etc., is not confined to doctors or medical men alone. It is confined. It is applicable to all professions. If I commit a negligent act in properly conducting the a litigation or a case that has been entrusted to me, I'll also be gauged with the same parameters. So will be an engineer who does not do his job well, or an architect who gives an unfeasible or unviable, what do you call, a drawing or something like that. So I would say that we should be happy that the people are taking recourse to this civilized form of dispute resolution rather than barging into your consultation room or hospital or taking law into their own hands. So, what is the accountability of a medical professional? The Supreme Court, in one of the, we all will be aware of this decision wherein it was finally decided that medical men come under Consumer Protection Act. For that reason alone, this case is being remembered. But still, the Supreme Court held that the medical practitioners are not immune from a claim for damages for negligence. The fact that they are governed by the Medical Council Act and are subject to the disciplinary control of the Medical Council is no solace to the person who has suffered due to their negligence, and the right of such person to seek redressal is not affected. So, like any other ordinary citizen of the country, howsoever high you may be or low you may be, you are also subject to, you means we all are subject to the rule of law or the legal regime of the country. Now, let us just analyze. Prevention is what the topic is. So let us first realize why an adverse decision comes, other than being really negligent. Number one is your failure to provide requisite information, data, or educate your lawyer properly. Or if you are doing it your own, there is no harm or there is no bar in the party himself appearing in person. You can also do that. But the failure to put forth before the court the relevant materials in the proper manner to substantiate your contention is the primary reason, other than being really negligent. Then number two is maintenance of record. In India, I'd say throughout the country, we don't have any particular law governing this. A K-sheet act or any. I'm not even seeing a proper guidelines which is applicable pan-India. It is institution-wise, state-wise, how it is to be maintained, how it is to be recorded, how it is to be preserved, how it is to be retrieved, how far it has to be. It changes, or it is dependent upon institution to institution. And except for, of course, Medical Council of India says if it's an individual doctor up to 3 years. Other than that, I have not come across any such thing. Then there is absence of clear clinical guidelines. Tendering of conflicting, confusing expert opinion, your own peer. In one of the cases, Dr. Rajaram would be knowing that wherein a forensic expert gave evidence in court saying that electrolyte imbalance could be an autopsy finding. We could demolish that and get across that case, of course, with the assistance of Dr. Rajaram as well. Then, of course, there is inadequate or vague laws. Why? Because now, for example, we had the earlier Consumer Protection Act. Now we have the current new Consumer Protection Act. There is still a debate going whether medical profession comes within the purview of the consumer protection or not. Why? Because it has not been clearly stated. But my take on that, I just answer it straight away, is that medical profession will come because the definition of service as it stood in the earlier act and the present act has not been changed. If that be the case, if the earlier act is the definition of service in the earlier act is construed to take in medical profession as well, there is no change that has been brought about. So I would say that, see, these are the issues. All the stakeholders are to blame, starting from the litigant, then the opposing doctor who is unable or not able to put it across, then the lawyer community, legislature which is unable to come out with proper laws. So then why blame courts alone? Now let us come to the medical legal issue. I'll just made it into three compartments. Number is awareness, then avoidance, and in the unlikely event of you getting embroiled in a medical legal or medical malpractice action, how to manage it. Just let us go along. Now see, there is no point in sitting around and crying, or saying that the entire world is no good, or we are being victimized, we are being given a bad deal, etc. It is just like saying that when you are surrounded by water, fences will be of no consequence. You will have to learn swimming. You will have to jump into it and learn swimming, and later you may even enjoy swimming. Likewise, medical legal education is a It should be made mandatory in the curriculum, not only in the medical colleges, and the vice versa, the reverse of medical science has to be made a part and parcel of the education in the law colleges as well, so that everybody will be able to help each other properly. And finally, this will all end up in a quality addition and a better way of justice dispensation in the country. Now, in a lighter way, I'll say that we have come across very many occasions where the vein murne blood complete പോയിട്ട് മരിച്ചു, അല്ലെങ്കിൽ എന്താ പറയാ, ഈവൻ അവർ ഓൾഡ് ഇൻ മലയാളം വി ഹാവ് എന്താ കേരളം എന്ന പേര് കേട്ടാൽ തളയ്ക്കണം രക്തം എവിടെയാണെന്ന് പറയുന്നത് ഞരമ്പുകളിലാണ്. So let us go from that to the basic. Number one, we are all aware of our rights, but we are oblivious of our duties. See, Chapter 3 of the Indian Constitution gives fundamental rights. Couple of pages thereafter, we have something known as fundamental duties, wherein every Indian citizen is supposed to or obligated to do, of which I am more concerned with Article 51AJ. That's the last one. Let us read it together. It is the responsibility of every responsible citizen. It's a duty of every responsible citizen to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievements. It just means that empower yourself, get the right tool, do your duties, whether you be a sweeper or the president of the India, discharge your duties properly. So there is no need for looking for a messiah to come and save the nation. If each and every individual empowers and becomes what I can say, excel in its own evocation profession, the country would automatically will become good. Likewise, we live in a country, like I stated earlier, where rule of law prevails. So ignorance of law is no excuse. You cannot plead that I was not aware that there was a law, because law is made by whom? The legislature. What is the legislature? Legislature consists of elected representatives. You elected them. So in fact, if you want to blame for a bad law, or if you want to blame that the legal system is not it is bit what can I say, not in your favor, or you are having any problem with that, the person to blame is look into the mirror, you yourself, because the legislature is constituted of your representatives and they make the law. And finally, in surgery, I believe there is a saying, the eye does not see what the mind does not know. So it is necessary that you should empower yourself to be aware how to react, how to respond to situations, not to panic. For which a primary or a basic awareness, I don't want you to learn the entire sections, cross sections, bisections, intersections of law, then we lawyers will be out of job. It is just like grandma's wisdom or mother's wisdom, or I'd say cook's wisdom, to be gender neutral. All of us cook rice. How do you know that the rice is ready to be served? We take one grain, crush it between our hands, and we know that the entire pot is ready to be served. We don't take the next grain to find out whether that grain is ready, and the next grain, etc. It's only one grain. It's a profound act. How to look, where to look, and what inference to draw from the materials you have received. That is the way legal education or education should be, is my submission before this August Assembly, because you need not run into different statutes, because India has got the dubious distinction of having the largest number of legislations or rules and laws, etc. Learning that would be an impossible task, and if you master that, I don't think that shows wisdom, but that would suggest that you require treatment. Understanding law is very easy. What is necessary is only common sense. If you can apply your common sense, then situations like this can be avoided. And everybody knows that the person in front should have a helmet. This is a photograph from your own place, I mean the capital of our state, Trivandrum, published in one of the newspapers. So that is the way. And why you should wear a seat belt? It is not to avoid the next policeman or avoid paying that fine. You should know the philosophy behind the law. So once you understand the philosophy behind the law, it will be very easy to be legally compliant. You don't feel that you are being asked to or compelled to, but you would voluntarily do that. That is what is lacking in this country. And regarding procedures, a protocol is there, but you know how to do it the entirely wrong way. When I say use the term you, please don't be offended, because I am also in that view. Okay, Now, what are the laws available? I just have a glimpse of that. We have the Medical Council Act 2001. You know what it is. Then Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002, which I shall be referring to in detail during the course of my presentation. Then Eligibility Certificate Regulations 2002. Then Screening Test Regulations 2002. Then Testing Laboratories and Experimental Institutions, Drugs and Cosmetics Act. There is a host. You can just see. And we have now the Medical Devices Rules also, wherein even stent and everything is now construed as a drug. Even a dental chair may come under the definition of drug now. So all the restrictions under the Essential Commodities Act, Drugs Control Order, and cosmetic may apply. Now let us see what negligence is. Can you hold that lady liable for the accident? Maybe she would have been the fatal distraction, but she is not, because she does not owe a duty to the driver. But in this also, the lady may not be liable if some mishap happens. The person wielding that shaving razor might be liable. This, in short, is the essence of the term negligence. And negligence, as it applies to all professionals, not be under the impression that it is confined to medical profession alone. Now, let us analyze the elements of negligence. There is a duty to care, there is a violation of duty, there is a resultant injury. Injury should be linked to violation of duty. This, in short, is what negligence is. There is a duty cast on every professional. It need not be a contract. It need not be. There is an implied duty of care. Whether you be a professional by doctor, engineer, lawyer, or whatever it is. If there is a violation of that duty and it has resulted in an injury can be loss, damage, anything, and this could be linked, there should be a nexus. Then these elements constitute what we usually call as negligence. I can put it in this manner. The earliest case or the case which we religiously follow is the Bolam case. Bolam case was, in that case, electroconvulsive therapy was given without using muscle relaxants. The patient sustained fracture. There were two body of opinion. One said that you need not give muscle relaxant at that point of time. I'm not talking about today's. You may also keep in mind that any professional will be gauged or adjudicated on a case of malpractice or negligence with the technology and the scientific knowledge on the day when the act or omission is said to have been committed or omitted to do. Here, whether the doctor acted in accordance with the properly held views of a reasonable and competent body of practitioners in field in question. That was the question asked. One of the earliest cases that went up to Supreme Court was that was reduction of fracture without using anesthesia. The patient went to shock and I think died also. In that, the Supreme Court in 1968, I believe, enunciated the law regarding medical negligence and placed heavy reliance on Bolam test. Now, in the recent rulings of Jacob Matthew and Martin D'Souza, it has been held that negligence is the breach of a duty caused by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. So, what is the parameter or the benchmark is a reasonable and prudent man. Reasonable and prudent man, when equated to medical malpractice action, is a doctor with equivalent qualifications, experience, etc. Would he, in the given circumstance, do that or omit to do that? I'll put it this way. Negligence is the breach of duty caused by the omission to do something which a reasonable man, guided by those considerations which ordinarily regulate human affairs, would do, or doing something which a prudent and reasonable rational man would not do. This, in short, is the quintessence or the definition or the parameter by which a negligence, an action under the tort of negligence is evaluated or adjudicated. It can be diagnosis related. We can just go through that. It can be advice counseling related. It can be treatment related. This was a case before the division bench of the Kerala High Court. The conscience of the court was shocked by the manner in which the treatment was given, and the court held this case reminds us of the cave doctor who uses crude instruments. And finally, the sentence ends by, and the anesthetist stands stands by with a club to strike the patient if at all he shows any signs of consciousness. In that case, the theory of informed refusal was also developed to a considerable extent, because we are only talking about consent. What about refusal? A specific procedure is necessary and the patient is not willing to do that. May not be a life-saving one or emergency one wherein you may be able to go ahead without his consent, whatever it is. So, if you say later, if something goes wrong or if he develops an adverse consequence on account of non-doing of that procedure, I could not do because the patient did not consent. Then the court will ask, or any reasonable man will ask, what is there to show that he was made aware of that it is necessity, and he refused? Then what is required is that, like a consent form, there should be an informed refusal as well. Now, in essence, this is what the legal mandate of the country, and for that matter, the mandate of any civilized country with a proper medico-legal adjudicatory process in place. The law does not insist that you should cure. It is care and not cure. What is important is not the consequence. The consequence will be drastic. The patient may die, the patient may lose a life or limb, or may be rendered in a persistent vegetative state, which will shock the conscience of anybody. But law of the country says that it is causation and not consequence. By causation, what is meant is that, are you in any way privy to part of the chain of events? Are you in, does your act or omission have any nexus with the final consequence? If so, you are negligent. What is required is reasonable care, caution, and attention. Once you can show that you have treated the patient, bestowing reasonable care, caution, and attention, that too as per the universally accepted standard medical protocol, whatever be the consequence, because you are not God, you cannot predict the result, and ex-patient may not be allergic to a particular drug, why may be, and that drug will necessarily be something that requires less dose. If the patient goes to shock and dies, what do you do? Or there are very many things, because medical science has not been and is not an exact science. It is accepted by the courts not only in India, throughout the civilized nations. What is required is ordinary skill of an ordinary practitioner. But if you, after your name, you put A, B, C, D, E, F, G, etc. and all that, then you profess or you hold yourself out as a specialist. Then you should have a higher degree of care and skill, because you make the patient believe that you are having some superior knowledge or superior wisdom, whatever it is, or techniques available at your disposal. Then specialists will have a higher degree of care and caution. There is a world of difference between elective and emergency life-saving procedure. In elective procedures, always it should be indulged if there are no contraindications. It is no defense saying later that these things were there, but still I indulged and it happened. If that be the case, you should have taken reasonable precautions. In the unlikely event of those known complications occurring, you are ready for that, or you are having the expertise and personnel at your disposal. Whereas in emergency life-saving procedures, all this can be given a go by, because the life of the person is more important than procedures. That is accepted by everybody. So what you have to do in emergency life-saving procedures, you cannot refer the patient elsewhere or send him off. You will have to stabilize the patient and then send him off to the concerned specialty or whatever it is for higher or better care, higher center. But in elective, unless and until you are fully equipped for all known or reasonably expected complications of that procedure, it is better not to invest and referring to the centers where they have all these things. Lack of facilities is not a defense. You cannot later on say that these, especially in cataract surgeries, etc., we come across a number of cases wherein saying that we needed such and such specialized equipment to save the eye if such and such complication arose. then the court will ask, were you aware or did you reasonably expect such a complication to arise? If the answer is yes, you should not have indulged because it's an elective surgery unless and until you made requisite preparations, or at least that facility on logistical grounds, it may not be available under the same roof. It may be in the next center, because nowadays these sort of equipments are worth a fortune. So in a city there may be only one, but still if you are able to refer within that required period, that is sufficient. Consent and confidentiality I shall come to separately. Now, one another aspect which we usually overlook is prescribing a drug of a pharmacology of another branch or another stream which you are not studied. An allopath prescribing Ayurvedic drug or an Ayurvedic prescribing allopathic drug. The Supreme Court has said in two cases. Number one is Samira Kohli case, wherein it has been said that even though the anatomy, etc., of human being may be same, and it is being taught in the same manner in different branches or whatever you may call it, allopathy, Ayurvedic, all those things. But the pharmacology, unless and until it was a subject matter of your study, you are not supposed to prescribe. And in Samira Kohli case, it even went to the extent of saying that even prescription, no proof is necessary of any adverse consequences. Prescribing a drug of a pharmacology which is not part of your curriculum of the degree you profess to have, itself, by itself, would tantamount to negligence. And in Balram Prasad case, another interesting thing was said: prescription of medicine without diagnosing the nature of the disease, without foresight of its implications, is negligence. Now, one another word on vicarious liability. Vicarious liability only says that for the act of the agent, the principal is liable. So, liability of the institution. In one of the cases which happened in Kochi, a patient under delirium in the ICU jumped off from the third floor. It was held that it is the one is vicarious liability, and there is a primary liability also on the hospital. Vicarious liability because the personnel in charge of the ICU did not take care of the patient properly. And number two is that the hospital should have taken primary care of having sufficient safeguards from patients trying act of flying, etc., from the third floor and other floors. Indian Medical Council Regulations 2002, 7.18. In the case of a running of a nursing home by a physician and employing assistants in helping, her the ultimate responsibility rests with the physician. That is there in the regulations as well. Government hospitals, there is an implied guarantee. There is both primary and vicarious liability. For example, in Calicut Medical College, there was a cluster infection wherein around 20 or 30% lost eyesight after cataract surgery. It was found that it was because of the unhygienic and improper sterilization and upkeep of the OT that this happened. And for that, the government was penalized, and of course, one of the doctors later in the second appeal we were able to get her off, but still the other two courts held when the first case of infection was noticed, the doctor also should have been careful. He should have been warned, or she should have been put to alert that this operation theatre is not fit for this sort of surgical procedures. That failure was content. But later, in second appeal, we were able to show that all the surgeries were done prior to the first case of infection was reported to the hospital, or the first case reported was not of a nature that it would give a reasonable doubt that it was on account of nosocomial or iatrogenic reasons. So, in a government hospital, two questions may arise. I am compelled to work in situations wherein there is no proper facilities. So, what do? I cannot say I cannot work because I am a government servant. So, what has been evolved by the court is that if you feel that there is no sufficient infrastructure, facilities, etc., and a catastrophe is impending, your duty is to report to the higher authority. Stop there. Nothing more to be done. You continue discharging your duties. And if something goes wrong, nothing happens. Otherwise, failure to report would tantamount to be a participant in that crime. Then, of course, cluster infection, we have said. If you see, trace the history of how the courts have decided, we start with Bolam. Then there is a paradigm shift. Now it is something known as Bolito. Bolito is in that case a child required intubation or oxygen had to be given. I think in that case oxygen was not available, but the patient was not intubated and died. When it came to the superior courts in the UK, the doctor and the hospital took up a contention that even if oxygen was administered, the patient would not have survived. And they adduced some expert evidence also. Had it been the Bolam test, that would have been the end of that case, because in Bolam test, if you adduce expert evidence saying that whatever you did is permissible and it is what it is, as per the medical mandate of procedure, protocol, etc., then you would escape. But in this case, the court held that this expert evidence can only be accepted if they are reasonable, and they should be substantiated by empirical evidence, either by authorities or something else. It is not a mere person, somebody coming into the box and saying that I got 50 years of experience, I say that this is something that is probable and there is no evidence. No. And evidence of a person becomes an expert evidence only when it is based on something. It is not is just mere statement. Oral statement will never get any weight in any court. It has to be based on some empirical evidence, some data, some authority, something like that. So now courts have assumed a more interventionist role. Earlier, it was, I won't say easy, because at times there is peer rivalry, but usually it was easy conducting, because I have been in this field for the last 30 years. So, when usually earlier times when cases used to come, what we used to do is that get two experts in the box and put some books and ask them whether it's correct, and they would say that all care, caution, and everything is seen given, and this is as per the universally accepted medical protocol and standards. Then that was end of it. Now that testimony has to be substantiated with textbooks, authoritative texts, etc. Then and then alone. There is a cleavage. In one of the cases, it was very interesting. Torsion testis was conservatively treated, in the sense like when there was all telltale signs of torsion testis, instead of an emergent invasive procedure and detorsioning it, the doctor waited and finally ended up in the loss of an organ. In that case, also, a finding was rendered against the doctor saying that even if you bring in an expert, it's of no consequence, because none of the medical textbooks said that weight. Even one of the standard textbooks says that even if you do an invasive procedure and it is found that it's not exactly torsion, but every indication was that you are excused because it is the procedure that has to be done. Now you can read the last paragraph. That is what Bolito suggests. Now, I'll put one question to deliberation before this August assembly. Peer review, is it a boon or bane? Now, as you all know, after the Jacob Matthew case, if a criminal case is charged against a medical man, unless and until there is a report from the local committee or by the apex committee, which is known as a peer review, that there is gross negligence, the investigating officer cannot go any further. Maybe that's good because a sudden arrest, etc., social standing. But does the law permit that? There is no such provision made in any of the existing laws. That is something that has been read into the existing laws by the Honorable Supreme Court, wherein it was said that a professional negligence cannot be equated with an occupational negligence or occupational hazard. Now, I'll come back to the point which I was trying to drive in. Peer review, what happens? The policeman or the investigating officer takes all the records and it is forwarded to the DMO. The DMO constitutes a board, and that board will go through the records and they will render a decision saying that there is no gross negligence. Then the criminal case will not proceed. You don't be under the impression that a civil suit or before the government or consumer case, you cannot. Other remedies there for the patient. But whether there is a criminal negligence or not is decided by this peer review. Now, forget about the criminal thing. Just imagine a decision is rendered from the records that there is gross negligence. Then whatever evidence you adduce before the consumer forum or the common law, the court will only say that your own man has found you negligent. Now it's only quantification of damages. And there is another problem. They don't interview, they don't take evidence of the doctor, they don't hear the doctor, they don't hear anybody for that matter. It's only, I had a case where in IV, Equilave IV was given, test dose given. So this expert body, I don't want to mention which where it was, said that Equilave was given intravenously. So that is negligence. Whereas the name of the drug is Equilave IV. See, had the doctor been given an opportunity to explain, that would have been, and moreover, there is that what do you call prick and that what do you call that? You put a round around it, no? When you have that subcutaneous, you know the procedure better. So I would say that the peer review, unless and until it is substantially reviewed and a protocol and a procedure put in place, would be more of a bane than a boon. And assume that the finding is in your favor. They say there is no gross negligence. It is of no consequence in a civil suit in a consumer case. They will say that it's only for criminal purposes and gross is not necessary for civil purposes. You need only have ordinary negligence. No need for gross or a higher degree of negligence. So what happens? You are back to square one. Whereas if it's against you, that will be used against you. Electrolyte imbalance, I already said. Now, this is the need not very much on this slide. Another concept is res ipsa loquitur. It only means that the thing speaks for itself. The Evidence Act, especially sections 101, 102, etc., says that he who asserts have to prove. That means that the burden of proving or the burden of proof is on the person who asserts medical negligence. But there are certain exceptions wherein the honest shift. Number one is if it can be shown that I have sustained some injury, but I can also show that something is there, like a mop inside my body or something else left inside my body, which ought not to have been there in the ordinary course of the treatment. Then the very fact that there is something that is there which ordinarily does not happen, and the doctor or the hospital is unable to explain that, then the principle of res ipsa loquitur applies, and the burden completely, the onus completely shifts onto the doctor or the medical man to disprove or to explain why this happened. Now, let us see the quintessence of what I have been talking for that. Then I'll come to the second phase and I'll close my presentation. So, to conclude my first phase of awareness of what exactly is the legal mandate of the country, we'll just see this. Medical negligence is the breach of a duty of care by an act of omission or commission by a medical professional of ordinary prudence. Actionable medical negligence is the neglect in exercising a reasonable degree of skill and knowledge to the patient to whom he owes a duty of care which has resulted in injury to such person. The standard to be applied for adjudging whether the medical professional charged has been negligent or not in the performance of his duty would be that of an ordinary competent person exercising ordinary skill in the profession. The law requires neither the very highest nor a very low degree of care and competence to adjudge whether the medical professional has been negligent in the treatment of the patient. The cause of action for negligence arises only when damage occurs. Since damage is a necessary ingredient of this thought, in a complaint of medical negligence, the burden is on the complainant to prove breach of duty, injury, and causation. The injury must be sufficiently proximate to the medical practitioner's breach of duty. Then, in the absence of evidence to the contrary, adduced by the opposite party is the hospital or the doctor, an inference of causation may be drawn even though positive or scientific proof is lacking. That is the paradigm shift that has happened in the last 10 years, or maybe more than that. That is, earlier it was for the complainant, the plaintiff, to prove and establish that there is medical negligence, which was a very uphill task. In one of the cases, the Supreme Court said that it is an impossible task because usually you don't get adequate literature. Now, after the internet explosion and Google available, it is at your disposal. But in the earlier times, it was impossible. And usually, lawyers never used to take medical negligence cases because once the effort that is to be put into it and the remuneration that would be given by the patient was not what I'll say worthwhile at that point of time. But now with the easy access to information, data, everything through internet and Google, etc., more and more medical cases are coming, and that too with substance. Unlike earlier times when the medical cases were just something goes wrong, you rush to the court, something like that. It's just easy to defend. Now it's not like that. Now the second phase of investigation is now that awareness is there, let us see how you deal with litigation. This is something that has been published by IMA in 2016, the largest number of cases, starting, if you can take a statistics of that. Now, why do doctors get sued? There are four main reasons for litigation. Number one is something has gone wrong, so somebody should be found responsible. That is, usually we call it as hunting for the man with the smoking gun. Somebody has been shot, and I have a gun which is smoking, so I should be. So the man with the scalpel or the person on the other end, usually the doctor is said to, if something untoward happens, and it is not able to be explained properly, even if it is explained the first blush, it will be against the doctor or the medical man. Accountability. The number two is the need for an explanation to know how the injury happened and why. Usually, we try to escape by the classic term of idiopathy, etc., which may not go down well with the patient or the bystanders or even the legal system. Then the concern with standards of care, the desire to prevent similar accidents in future, so that there is an old saying, you are not being punished for stealing the horse. You are being punished that horses shall not be stolen in future. That principle. Compensation for actual losses, pain and suffering of the, then recompensate for the loss that has been caused and occasioned to the patient or the his relatives if he is no more on account of the negligent act on the part of the professional. This is a reality. Now everybody knows there is a joke going around that is the patient went to the doctor not for a medical opinion but for a second opinion. The first opinion is already received from the Google and the web-enabled technology has given him. Now he wants a second opinion from the concerned doctor. Now it all starts usually with a verbal complaint from the patient. If we have a good PR or we have, I'm talking about an institutional based thing, we are able to manage it properly and see to that from the first, you may kindly note that the threshold of interaction of a patient or bystanders in a hospital is not with the doctor or the high level management. It is usually with the lower cadre, not in any way belittling them, but those persons who like the sweeper or the housekeeping staff, etc. So it is better and advisable to pamper and keep them good humored, that if at all any discussion happens between the doctor with the patient or patient party with them, let them say something positive about the institution and the doctor. Just imagine a situation wherein the patient or the bystander asks, okay, we are under the treatment of Dr. X, how is he? This sweeper or the housekeeping staff only said, something like that, if you make him to give the best treatment, they may not be satisfied. So once you have a verbal complaint, listen, understand his problem, explain, offer solutions, politely decline unreasonable settlement. Why? Because settling or hushing up in a hurry would only encourage this. Then you become a milking cow. Then everybody knows that go to that institution, make some sound, and you get money. Instead, see to that there is a system in place to deal with this. Like you have code blue, code, etc. If there is a problem, we can say it's a code something. So that the concerned staff who will be dealing with the outside world, including media, let them speak the same language. Let there be no conflict of what they are saying. And see to that they are well educated about the situation. And I'm talking about unnecessary cases being filed. It's not I'm advocating any sort of mechanism of dealing with negligent action. We'll see about it later. But here, for all conceivable reasons, you have problems arising in hospitals and institutions. So I suggest that. Then once that is not settled there, then comes legal notice. Legal notice, it can be replied either by yourself IMA has got the professional protection scheme. Indian Dental Association also has their own schemes wherein the data and knowledge available are pooled into one source so that they'll be able to assist you in giving a proper reply by giving you the correct inputs of what the legal scenario, what the latest medical situation or justification, or if you are really negligent, they will also tell you that you are negligent. In reply, what has to be thought of is there should be proper refutation because it is better to put your case in complaint in toto in that so that the patient party who receives the reply when he shows another expert or a lawyer, they would say, see, they got their own explanation, which is scientifically and medically correct. Let us know. There is no point in going for a litigation. But if you give only one syllable line saying that you are not negligent, etc., that might only instigate, saying that, see, they didn't even give a proper reply. I would suggest an advocate that a proper detailed reply would always be advisable. And please remember, written replies are addition. Usually, if you give a proper reply, almost 90% of the complaints are resolved at that point of time because they were aggrieved, they got an explanation. And explanation maybe they may not be fully satisfied, but they will understand that you got a reasonable and a valid and a scientific defense in place. Then usually it does not go any further because indulging in litigation is also as difficult as defending litigation. Now comes the second and the third stage, going to court. When you go to court, if you are not planning to appear in person, see to that you get a lawyer, a trusted lawyer, whom you can educate properly or who has some knowledge about this, at least the distinction between a nerve and a vein. Then you can review the case with your colleagues. I don't mean by colleagues who have got experience with somebody who has been sued 100 times. That does not show that he has got any specific knowledge. It only shows his inefficiency and negligence. What I was suggesting is that there will be persons like the honorable speaker who has to speak before me, who is a medical man, has shown interest in learning the what do you call interface of law and medicine. Persons like that who have a penchant for learning and who are exposed to these sort of things could also be consulted. But luckily in Kerala, we have both IMA and IDA have a legal cell wherein all these things are being given to the members. If there is a genuine case of negligence, it is, I would say that it is better to say sorry and settle if possible, not unreasonable settlement, because a case fought out for years is not worth your time and effort. If you feel that there was some omission or act on your part which should not have been there, try to settle it if possible. And you may also, if possible, update your knowledge because usually once we leave our alma mater, then our entire knowledge is provided by these medical representatives and others who give you literature which is primarily intended to promote their products and nothing else. And upgrading oneself with the science, technology, etc., is necessary because you will always be gauged, you will always be judged by the scientific knowledge, theory, expertise, equipment available on the date of treatment, not when you took your MBBS or other degrees eons ago. And it is better to work closely with your lawyer because he has to be. We had different cases wherein in one of the cases, yes, there was an infection of the eye, cataract surgery itself. The swab culture showed spore forming something that is a bacteria. But the causative organism was Pseudomonas aeruginosa. The court was not able to be properly educated or assisted in this matter. And finally, the decision of the law forum came that this spore forming non-pathogenic dust for what do you call bacteria later on became Pseudomonas aeruginosa, and it created all the difficulties. Whereas microbiology, the standard textbook or even the primary textbook showed that the Pseudomonas aeruginosa does not have a spore forming stage at all. And even though it is a bacteria or whatever it is, it does not change from one to another. It is just like saying that somebody went for an interview. He answered everything beautifully, but finally, when a question was put, something happened and he came out. Then the next person asked, "Why you are looking so sad? I'm sorry, just put the battery properly." Yes. You answered everything properly. Then he said that finally they asked to show my testimonials. I think I showed them the wrong thing. So the same thing happens unless and until you educate the lawyer properly. If a question comes from the court, he may not be able to reply properly, and that may result in a catastrophe. Appeal only if you are confident, because lower court decisions are entered and kept in lower court itself, and it does not get reported. But when as you go higher and higher, and an adverse order or something is, you become immortal in the sense like that will be reported in the journals, etc. If you don't want to have that, and if you are not that confident in the case, be satisfied with the judgment of the lower court itself. Now, how to prevent it? Number one is communication. If there is proper communication, and if you can take the patient and patient party into confidence, usually minor mistakes, etc., will be excused, because they also know that the doctors are also human beings. There is always a possibility, in spite of all the qualification, all the experience and expertise, something will go wrong. They may excuse. So communication is the primary thing which has to be taken care of. I'll just collate the reasons that has been found. Number one is improper behavior. If you assess the number of medical legal cases that have come in the country, if you go to the genesis, it is not usually because, of course, there are cases which comes primarily and only because of a proved or known complication or negligence on the part of the doctor. Usually, it is that sense of getting back on the doctor for not having properly behaved. So, it is just like saying, go to the patient and ask him, would you like to know the good news or the bad news? So he'll say, I would like to know the good news. You are going to have a disease named after you, instead of telling him that you got a deadly disease and you are about to die. So behavior is one thing. Second is, of course, whether you like it or not, your colleague. You go to a second center, then he'll say, oh, if you had brought him 5 minutes ago, I could have done wonders. There's an old joke also which says that a patient is rushed to a hospital. The doctor says that you should have brought him 5 minutes ago. Then the answer given by the bystanders is very classic. We should first fall from the coconut tree, no, then only we can bring, like that. Then there is commercialization, and that has now translated to negligence to a certain extent. There is also indifference because of that doctor-patient ratio. International standards and national standards I don't want to mention, because and all other things you can, and there is increasing dehumanization of medicine, routines that have as the point of reference not the sick person but paper and machinery. All these things, caution factors I already mentioned. And how to prevent? Number one is getting informed consent. Informed refusal also I mentioned earlier is equally important. Whether you anticipate unpleasant why this is because consent does not save you from acting negligently, but consent saves you from harm that is caused even though you are not acted negligently, because there is a principle in law which says that voluntary non-fit injuria, that injury by consent, with consent, does not give rise to a cause of action. So I fully knowing that there is a possibility of this and this untoward incident happening in spite of the best care, caution and attention on the part of the treating doctor, and still says that you go ahead doctor. The doctor performs the procedure and one of these known and declared complications happen, then the patient will not have a cause of action. That is the importance of consent. Don't be under the impression that I take consent and then I stab you, then there is nothing. No, it's not like that. It only shows that something happens, a known harm or known complication happens in spite of the best care taken by you for reasons beyond your control. Then consent saves you. Otherwise, that also will loom large against you. The patient would say that, had I known that this sort of harm, consequences, complications were there, I would not have undergone this procedure. It is just like saying that I sustained a fracture. I can go for the old conservative POP cast and wait for 3 months or 4 months for my reduction of the fracture. Whereas it can be done invasive procedures or external fixators, etc., which may be fraught with complications, which unless and until you get a informed consent, there is a problem. And if the patient says that I want the conservative method for a comminuted fracture or something else, and we say that unless and until there is a K-wire or something has to be placed for it to have a proper reduction, or there is walrus, or there will be some problem with your hand, deformity. Still, he says, no, doctor. I come from a family where we only rely on this sort of plaster or kettle matra gondu ennu paranjal. Then you will have to have it recorded saying that we suggested such and such procedure, but the patient refused. Hence, the other one was done. That is conservative method was done. Regarding consent, do not operate beyond the consent given. Consent given for one cannot be taken for consent of another. It should be real and valid consent. It should be free, informed consent. You cannot dupe or you cannot conceal matters from the patient and get a consent. Now, what does our professional regulation says? Conduct etiquette regulation 7.16. Before performing an operation, the physician should obtain in writing the consent from the husband or wife, parent or guardian, in the case of minor, or the patient himself, as the case may be, in an operation which may result in sterility. The consent of both husband and wife is needed. Then 7.21. That is regarding fertilization. You can just read that. Then comes the next important thing of confidentiality. Regulation 7.14. The registered medical practitioner shall not disclose the secrets of a patient that have been learned in the exercise of her professional except in the court of law under orders of the presiding judge in circumstances where there is serious and identified risk to the specific person and or community and notifiable diseases in case of communicable, etc. So, in the present scenario or in the earlier HIV scenario, a matter had, in the HIV scenario, AIDS scenario, a matter had gone up to the apex court, wherein the court held that disclosure was necessary in the larger public complaint. That is regarding confidentiality. Then privacy. 7.17 of the regulations. A registered medical practitioner shall not publish photographs or case reports, etc., etc. You can just read that. Without the permission in any medical or other journal in a manner by which the identity could be made out. If the identity is not to be disclosed, the consent is not made out. See, consent also required for photographs, etc. That I shall deal in separately if at all any question arises. But you may take it that unless and until you get a proper consent, these things which makes an intrusion to the privacy of the patient cannot be indulged in. Then regarding fee, one of the triggering elements of the rise in litigation is because the fee or the expenses related to treatment has shot up. So if I pay something more, I need a better one. If I purchase something for 10 rupees and it does not work, I just throw it off. It's okay, fine. But if I pay 1 lakh and I take it and if it does not work, I'll go behind you. So that is also the fee factor. It's not, I don't say it's alone because something goes wrong with me and if I'm suffering, whether it's 10 rupees or 1 rupee, I may go behind it. But still, that is why on the right way it is said that a doctor is defined as a person who kills your ills by pills and kills you with his bills. And in the regulation, there is a 3.7 regulation wherein which says that you will have to exhibit the charges, just like walking into a hotel, it seems like. Then the most important thing is maintenance of records. I would use the term robust documentation, which is used by the Supreme Court as well. You will have to standardize it. There should be a medical records library. There should be a custodian. There should be proper history, everything. And for that matter, taking proper history, I think it was a joke running in Calicut Medical College, wherein a patient comes to the regular questions, parent, name, father's name, etc., etc., and whom all in the family have the same disease. He has come with a coconut falling on his head. So that has become so mechanical nowadays. That's also one of the reasons. And prescription. Now, after the recent regulations and guidelines, it is imperative that you write everything properly. And I shall bad handwriting by doctors is responsible for 7,000 deaths every year. Fact of the matter, in Bangalore Times, it was published earlier, which I thought I'll share with you. Prescribing error may be considered one of the pathways to medical error, may lead to severe safety issues to the patients. The results of the present study show that it is necessary to critically address the completeness. So that is why we have the usual criticism is that it is the pharmacy companies which dictates which medicine is being prescribed. In the present era of knowledge explosion, neither patient nor anyone can be kept in darkness regarding the whole process of patient management. Every patient has also got the right of information. Now, in the regulations 1.5, use of generic names of drugs. Every physician should, as far as possible, prescribe drugs with generic names, and she shall ensure that there is a rational prescription and use of drugs. The above clause 1.5 is substituted in terms of notification published in Gazette of India on 8/10/2016 as under. Every physician should prescribe drugs with generic names, legibly and preferably in capital letters, and she shall ensure that there is a rational prescription and use of drugs. On the lighter side, we used to hear stories of a doctor writing a love letter to the nurse or someone else, and unable to read, the nurse or the lady takes it to the pharmacist. The pharmacist looks at it, and the first leg of the earlier story was that he is able to read it, and the second leg, now what has been changed is that he looks at the letter, pulls out a drug, and gives it to the lady. That this directive is expected to reduce the number of potential medical errors that occur due to illegible handwriting and spelling mistakes. Poor handwriting undoubtedly contributes to high incidence of medical errors. Now, regarding fees, I mentioned earlier 3.7. 3.71. A physician shall clearly display his fees and other charges on the board of his chamber and or the hospital he is visiting. Prescription should also make clear if the physician himself dispensed any medicine, because otherwise you should have a pharmacy license and a registered pharmacist if you are running an open shop or vending it across the counter. For your own patients and for the use of your own patients, you can keep that, not otherwise. 372 also may be read 2A. There is a note appended to 372A. In government hospital where the patient load is heavy, the name of the prescribing doctor must be written below his/her signature. These are the attributes of a standard prescription. You can just run through. I don't want to take your time. Even now, I think I'm consumed more time. Let's see. I'll just finish off my presentation. It is advisable to have prescription audit periodically to know whether there are any mistakes or omissions or errors in the methodology being adopted by the establishment. Then maintenance of records. I'll only draw your attention to 131. It is 3 years. That is only regarding a physician. Nothing is stated about a hospital or an institution. And the mandate of providing a copy, that I'll just take 1 minute on that. Hospital records or records of the patient, we are under the impression that it is a property of the hospital. But just read 132. If a request is made for getting that, and also the latest act, that is that hospital attack, commonly known as the Hospital Attack Act or something like that. Prevention of attack on healthcare workers, personnel act or something like that, Kerala Act. In that also, once a request is made for medical records, it has to be provided within 72 hours. You cannot withhold that. Now, regarding this documentation, I would say that document is the only piece of evidence that will be able to save a medical man in the unlikely event of a medical malpractice action being initiated against him. Because that contemporaneous recording carries much weight and is relied on by the court once it is shown that it is being regularly and properly kept in the regular course of activities of the hospital, and that the possibilities of compromise or tampering is eliminated. Then that will be accepted by the courts. And if you can get an expert come and say that whatever is being recorded in this will is the proper manner of management, or this is the protocol that is to be accepted and adopted, then whatever be the important consequences that may follow, you may escape. Then after the introduction of the IT Act, that is EMR is now Information Technology Act has made it possible and legally acceptable to have electronic records or digital or digitalized records. That also can be explored, and we can take advantage of that also. Now comes the next question of referral. It is better to refer appropriately. Delay in referring or retention of the patient beyond your ken or your knowledge, etc., or your capacity to manage the situation, it may amount to negligence. That is why in Lakshman Balakrishna Joshi's case, the Supreme Court said, this is the case that I mentioned earlier, that is reduction of fracture without using anesthesia. The patient went to shock and died. That is in 1969. A doctor is expected to possess the average degree of skill. The treatment may differ depending upon the different choices available. However, it is expected that the doctor shall not undertake any procedure beyond his skill. So, just to summarize, I would say that the actions required from the part of the reasonable medical practitioner is it is better to have a smiling face, take proper history observation, maintain proper record, see to that you get informed consent or informed refusal whenever necessary. You should be fully equipped to indulge in any medical procedure. So that reference at the first instance, and keep yourself abreast with the latest development. Continuing medical education. I would also add continuing medical legal education also. Keep yourself abreast with what's happening. Then it's better to have a personal indemnity insurance and transparency. So this can be put in this one: a rapport with the patient and the bystander. The rationale of the treatment has to be given. Records has to be maintained. Unnecessary, what do you call? Remarks, etc., could be avoided. Don't give any false assurances. And in Poonam Verma case, it is specifically it is in Poonam Verma case that pharmacology of one cannot be used in the other. Then I earlier said Samira Kohli. Samira Kohli is with consent. I'm sorry about that. Samira Kohli's case was regarding consent. But Poonam Verma's case is regarding what do you call a prescription of a medicine of a pharmacology which you are not studied. You may just note that. Then, as an association, you can conduct continuing medical education, medical legal education. Let there be proper clinical guidelines. We have associations for all specialties. Let the specialty come out with guidelines. Let it be got accepted by the system. Then it's very easy, because then one need only show that you are subscribed with the guideline. No need to, for example, DNC. Continuing pregnancy is an accepted complication of DNC, dilatation and curative. And if there is a corneal implantation or a dual pregnancy, etc., in every case, we'll have to start by saying that it's a blind procedure, the cervix is dilated, then inside is scrapped with an instrument known as curette, etc., and all those things, and products of consumption, etc., is sent for histopathological examination. Instead, if there is a guideline, once DNC is done in a procedure, the doctor need only say that review after such and such time, so that it will be within the MTP period if it or there is a continuing pregnancy. I just cited an example, maybe wrong, but still, I am trying to improve upon that. If there are clinical guidelines, it will be very easy to deal with the situation. Then let there be a proper, effective ethics and disciplinary committee or an ombudsman, so that the common man will be much more confident that there is a policing mechanism or there is a disciplinary authority, so that erring or negligent or indifferent persons will be taken to task. Then, of course, we have the legal cell, etc. And it's better not to sponsor litigation, because nowadays, because of the rising commercial and the investment factor in this sort of new hospitals, there is always a tendency that we would like to see to that the hospital suffers. And just imagine that the same thing happened to you also. I would also say that don't cover for negligence of another. One word about medical devices rules. I'm not taking through the other slides. It's only this has come into place, wherein now devices are equated with drugs. So all those parameters applicable to drugs are now applicable to medical devices. It started off with certain stents, etc. Now it's made applicable to everything. 15 medical devices were regulated earlier. Now, slowly, all implantable medical devices, CT scan, MRI equipment, the defibrillators, dialysis machine, PET equipment. Now, this British Technical Advisory Board is drawing up a patient compensation plan for faulty medical devices. Earlier, if something goes wrong, you sue the hospital and the doctor. There is no separate segregation because even if it was a failure of the device, now that is being segregated. That I think is a good move because these multinational manufacturers, etc., will be liable if the equipment malfunctions or there is any error on account of the equipment or device. You can just see that. So, to conclude, the essential components of negligence are three: duty, breach, and resulting damage. Lack of care. How the courts have analyzed it is a simple lack of care, an error judgment, or an accident is not proof of negligence on the part of the medical professional. So long as a doctor follows a practice acceptable to the medical profession of that day, he cannot be held liable for negligence merely because a better alternative course or method of treatment was also available, or simply because a more skilled doctor would not have chosen to follow or resort to that practice and procedure which the accused or the opposite party followed. Then failure to take steps. When it comes to failure of taking precautions, what has to be seen is whether those precautions were taken which the ordinary experience of men has found to be sufficient. A failure to use a special or extraordinary precautions which might have prevented the particular happening cannot be standard for judging the alleged negligence. Standard of care as from the date, that is, the standard of care while assessing the practice as adopted is judged in the light of knowledge available at the time of the incident. Then a distinction between civil and criminal negligence. The question of civil negligence may normally arise when either the patient dies or is not cured or some harm is happened to him. However, the civil negligence may be alleged by the aggrieved where the doctor owed him a duty to a particular standard of conduct, but he was derelict and failed to perform the duty, resulting into suffering of actual damages and the conduct of the doctor being the direct or proximate cause of the said actual damage. In criminal negligence, it is death or serious injury to a patient. Rational negligence on account of. The doctor may be charged under section different provisions of IPC. Now, already talked to you about the peer review that is necessary to proceed. But even if the peer review thinks that there is no gross negligence, nothing prevents the investigating officer to request a further opinion or approach the apex body headed by the DHS. Now, to conclude, medicine is not now and never has been an exact science. Despite the exercise of the greater skill, things can go wrong. This is how the courts view medical negligence. And whatever be the consequence, if you got an explanation for the causation, the court will accept that, provided it is scientific, reasonable, and accepted by the medical community or substantiated by medical literature. There should be a proper explanation. The present trend is that the patient can discharge his initial burden by just showing that I underwent the treatment or underwent the procedure and I have sustained some injury. Then the onus shifts on the doctor and the hospital to show that this is a non-complication, non-harm, and in spite of the best care, caution, and attention, this may at times happen. This can never be equated with any negligence. I hope my presentation was not like this. Something would have. I hope that it would bring out some positive thoughts in the minds of the listeners. And What is necessary is to adapt to the changing scenario. There is no question or there is no point in learning or trying or waiting for a message to come and say all that. If we adopt the standards that is required, the standards that are in place, what is the legal mandate, if we understand, once we are aware, we can avoid, and even if we are not able to avoid, in the unlikely event of we are embroiled in any litigation or legal issues, we may be able to manage properly. It all depends upon you, your priorities. പട്ടിയാണോ കുട്ടിയാണോ കരുതുന്നത്, you'll have to decide. I would say that when it rains, look for rainbows. When it is dark, look for stars. Thank you very much for your patience. I am conscious of the fact that I overshot my time, but Dr. Rajaram had given me an indulgence saying that time may not be a issue. That is why I indulged. I'm sorry if I took your time in the Sunday morning. Thank you very much for your patience.
Dr. Geeta, would you please sum up?
So first of all, let me thank Shivshankara Pillai sir for initiating or giving stimulation and motivation for starting this particular forum, and for Rajaram sir for materializing it. And let me thank Dr. Advocate Shyam Padman sir for this beautiful presentation. And being forensic medicine people, we have some connection, or it is interface between medicine and law, and we have some knowledge about law. But this type of deliberation is actually very difficult for forensic medicine people to do by ourselves. And so thank you, sir, for this vivid description of this prevention of medical negligence. And sir has, let me sum up the whole thing. Sir, Shyam Padman sir has first said why doctors consider this as a blame game and why we should not do that. And he described the importance of law and why the court is taking such a decision. It is to protect the community or safeguard the rights of the people. And he described the organs of government like legislature, executive and judiciary, and the roles of each one. And why those adverse decisions come in medical negligence cases, that is being other than being really negligent or tendency or having some confused ideas or confused opinions by the expert and inadequate or vague laws in certain issues. And he says that the medico-legal issues, while for dealing with medico-legal issues or to reduce the number of negligence suits, the first and foremost thing that has to be done is awareness, or by empowering the medical education regarding medico-legal issues, and then avoidance of such negligence cases and management if occurs, if such a medico-legal issue occurs or negligence suit occurs, how to manage that. And he said that fences are not sufficient, and to prevent a person from drowning himself, it is the best way is to learn swimming. I like that very much. Then and he said that we are very much aware of our rights but not about our duties, and we should be, our ignorance of law is not an excuse. That is a dictum that has to be followed by each and every citizen, especially doctors. Ignorance of law is not an excuse. Then he described, or he gave description, detailed description for the elements of. Sir, it's slightly disturbing, sir.
If others can mute, if all others can mute, it's very beneficial.
So Shyam sir has described the elements of negligence, like a duty of care and the dereliction of dereliction of duty. That is, if the person is not properly doing his duty properly, and if that dereliction of duty has caused damage or harm to the patient, and there should be a direct connection between the negligent action of the doctor and harm, then only that action would be considered as negligence. That is what he said. Then it can be, then he described the definition of negligence. It can be either an omission or a commission, doing something which is not expected from the doctor, or not doing something. Then he said that the court expects only a reasonable amount of skill and care, and not a very high degree of skill or very low level of skill and knowledge. So a reasonable degree of skill and care and knowledge alone is expected from a doctor. Then a lack of competence in a hospital is not considered as a defense. And he told about the allopathy and Ayurvedic preparations. So allopathic doctors are not supposed to prescribe allopathic because it's a secret remedy, where the constituents or composition and the mode of action of those drugs are not known to the doctor. So we are not supposed to do that. And he introduced two terms. We are also aware of some of the aspects of that: vicarious liability and res ipsa loquitur. So those things, the hospital and the seniors will also be held responsible for some of the actions of the doctors. And then res ipsa loquitur, and the burden of proof will be shifted from the complainant to the defendant. In res ipsa loquitur, where the thing speak, we usually call it thing speaks for itself. Then he described the reasons for litigation, like accountability. If something goes wrong, someone has to give a reason for that wrongful. That is, someone should be made accountable in majority of the situations, and there is a need for explanation why that harm has been caused, and the concern of standard of care to prevent further damage in the future, and the need for compensation. And
വിധാമേടം ഒരു സെക്കൻഡ്, ആ ബാക്കി 3 പേരും കൂടി ഒന്ന് മ്യൂട്ട് ചെയ്യുകയാണെങ്കിൽ ഈ എക്കോ വരില്ല. ബാക്കി 3 പേരും കൂടി ഒന്ന് മ്യൂട്ട് ചെയ്യുകയാണെങ്കിൽ ഈ എക്കോ വരില്ല. എക്സെപ്റ്റ് ഫോർ ദ സ്പീക്കേഴ്സ്, ഇഫ് അതർ മ്യൂട്ട്, ഈ എക്കോ വരില്ല.
Yes, thank you so much. Thank you. Then he described different steps of preventing or different steps to be taken, like when there is a verbal complaint from the patient, that has to be properly entertained, and somebody should hear that, and somebody should provide the reasons for that. And if there is if we take a compassionate reaction towards that patient, most of the litigations can be avoided. Then comes legal notice. The person has to properly acknowledge that one, and by giving point by point refutation, and by being transparent, litigation can be prevented, or at that point itself most of the things can be stopped. And then if it is going beyond that, we have to go to the court, and we have to take legal advice, or we have to engage a legal expert. And before that, we have to have a discussion with our colleagues who have some amount of legal knowledge, not to others who do not have any knowledge about the legal matters or about the subject. An expert should be found out for that aspect also. Then he told about the prevention of litigations, that is the importance of proper communication, the importance of informed consent, as well as, or equally or more than informed consent. I think sir has stressed about informed refusal. There should be documentation of informed refusal as well. Then while fixing our fee, it should be a reasonable one, and if possible, it has to be explained what is the criteria for fixing that fee, and importance of documentation, proper documentation, and importance of medical records maintaining, and the proper method of prescribing. I think the MCI has given a proper guideline for prescriptions by writing generic names alone, and using capital letters and all. There are certain problems with that also, and the practicing doctors are here, and they would be able to give some insight into that. Then prescription, about the prescription audit, then then the importance of referring properly. When you think that you are not competent enough to tackle that situation, the reference should be made then and there itself. And he highlighted the importance of continued medical education programs like this. I think that would empower the faculty members working in a particular field to tackle the situation, and would be able to gather information from other experts from other fields, which is very, very important for the doctors, especially the forensic medicine experts. And at the end, he said that the medicine is not an exact science, which is a basic principle or to be considered while dealing with medical negligence cases, especially by the lawyers and by the judiciary. Thank you so much. Thank you once again. Thank you, Padmin sir, Shyam Padmin sir, for this beautiful presentation. And over to Rajaram sir and to Shivashankar Pilla sir for further deliberations. Thank you, sir.
Learned advocate, my dear friend, Shyam has given an excellent comprehensive package. It was very educative, interesting, and well encompassed. Maybe in such a short given time to have explained so many points with clarity is a great job. Thank you very much, sir. We are indebted to you.
Thank you, sir.
Welcome, sir. And
any questions from the
yes,
participants can be entertained. I think we can permit 10 or 15 minutes for that. Isn't it, sir? Rajaram, sir, we can permit 10 or 15 minutes.
Sir, Shyam, sir.
Yes.
Sir, very nice presentation, sir. The good thing I liked about is the use of cartoons which you have kept us on the toes, like, but the presentation does not get monotonous and boring. My question was, see, there was a lot of stress on informed consent and informed refusal. Sir, right. Am I audible to you?
Yeah, definitely, sir.
Yes. So, sir, of late in the literature, I have been also reading about a term called as understood consent.
Yes.
So, can you shed some light on this aspect of the difference between informed consent and understood consent?
See, basically, there is only one concept under law, which is known as consent. Yes. We have added the free, informed consent, etc., etc. That's all adjectives given. It only emphasizes the importance that it is not mere or mechanical reproduction of the complications, etc. But see to that the patient or the bystander, as the case may be, has fully understood and comprehended the procedure that is to be done, number one, the possible and probable consequences, and the alternatives that never we thought of. See, there can be alternate, your institution may not be having that, but still there is always a possibility of an alternate or a better procedure elsewhere. That also has to be, and you will have to record that I told everything, and it is seen that the patient or the bystander understood what I told them. The importance is not you doing something, you just discharging your duty. No, that should bring about a result. The result is what? An educated, the consent is the basic basis of consent is the human right of self-determination. The foundation of consent is what? It's a basic human right of self-determination. I got a right to determine what should happen to me. You are not to dictate that this is the best treatment, you will live for 120 years. No, I don't want to live for 120 years. I would like to die day after tomorrow. So it's my volition. So the science or the theory behind is self-determination. So if you are to determine something or if you have to take a decision, you should have the right inputs. I should understand that these are the options available. That is why it's known as a free informed consent or an understood consent or what. But basically, consent is nothing but the patient or the bystander or the person who has to take a decision being made aware of all the possibilities available and the pros and cons of each possibility. Possibility means it may be procedure or treatment protocol, and it is for them to decide.
Sir, I have
Thank you, sir.
Thank you, Dr. Ravikant. Sir, I have a question. Rajaram, sir, can I ask questions?
Sure.
Okay.
This is an informal session. I mean, even I am not here to answer. I'm here to learn something from you as well. So as long as we don't exchange ideas, I will also go back empty-handed. I don't want to do that.
Sir, if it is a life-saving measure, like giving CPR, and if the relatives or the bystanders or the next of kin is not willing to resuscitate that patient, and they say that there's no need for giving CPR. And as far as a doctor, it is a duty of the doctors to save the life of the patient in an emergency situation. If what decision has to be taken in such a situation, whether to comply with the decision of the relatives or to follow our rules or guidelines?
Geeta madam, it has to be understood in two ways.
Sir.
Now we have something known as, I'll come directly to our question, but we have something known as living will or advance directives in place, which has now been recognized by the Supreme Court. See, even though there is no law, I can say that I should not be put into ventilator. I should not be resuscitated. But all those things are regarding or pertaining to aging and natural death and preventing of a natural death. But an accident victim comes or someone else who requires resuscitation, it is not for the bystanders to decide whether to murder him or not, if I may use that term.
That was my doubt, sir. Regarding living with the person.
If I directly answer a question that you can, then you will think that everything comes in. You can't. The other thing is known as advanced directives or living will, wherein usually somebody who's 95 or 105 and he goes and he'll be put into ventilator for 1 month or 2 months. Whatever he has earned in his entire life will be given to that hospital, and his children, etc., instead of crying, will be cursing him. Yes. That's one scenario we'll have to be very much alive to. And as far as resuscitation is concerned, no permission from anybody is necessary in other scenarios, trauma victim and things like that. And we had cases wherein breakage of rib bones was reported, and it was stated that the patient fell off the bed, and that is why it happened. That was the allegation made. Whereas we could get a forensic expert or an expert come and say that at times when you give CPR, there is a possibility of hairline fracture or something happening to the ribs.
So another point, sir. In the negligence cases, you said that investigating officer can re-investigate a case even if the court has found that.
No, not the court.
Not the court. Then
no. Re-investigation can be requested for by the investigating officer even if the DMO and the peer review is found that there is no. He can still say that that's not correct. He can require and he can oppose the effect DHS.
Oh, okay, sir. Any other questions? I have few more questions, sir, that we will discuss later on, sir, through personal message or through Rajaram, sir. Anyway, we are.
I'll be more than happy to share whatever little information I have. I'll look eager to learn from you all also.
Thank you, sir. So
and one point.
Yes.
DNR, that is, do not resuscitate has no legal sanction in our country.
It has got
no legal permission.
That you cannot like that. After that 2018, you just go through that judgment. It was the earlier 2018 judgment has said that if it is a persistent state and no productive life, or the term used is that productive life. I don't know the exact term because that not being the theme of today. Just read the 2018 judgment. That is beautifully written and that runs to around 100 pages. But once you read it, you will also love to write a living will. or what do you call the pros, the cons, the possibilities of it being misused. Everything has been dealt with and beautifully written. I'll share the judgment, the citation.
No, I have. The procedure is what it's
I didn't get
too
it.
lengthy. That procedure for
Right,
it.
not like the other one. Here, this is a bit. We are not talking about euthanasia. Don't confuse that. Euthanasia is an entirely different. Don't confuse that. This is euthanasia is active euthanasia. We are talking about passive euthanasia. A distinction has been drawn. One is pulling the plug. The other is putting in somebody into life-sustaining system, whether he likes it or not. It's a whole world of difference.
Sir, Rajaram sir, with your permission, shall we move on to Dr. Padma to continue with his topic? Shall we, sir? Shall we? Dr. Padma.
Yes, I'm ready. Okay.
Yes, yes.
Okay.
All the best, Padma.
Thank you. It's visible, sir?
Yes, it's visible.
This is where it got interrupted, sir.
Different laws, that is constitution, then common laws.
Okay.
We mentioned about the constitution, statutory laws. Just a mention of
Okay,
statutory law and common laws. That's all.
Yeah. Yeah, please share the screen. Okay. It's visible, ma'am? Okay.
It's visible.
Okay.
But slide share should be there. Slide share.
It's done.
Yes. Yes. Now it's okay. Now.
Okay. Okay. It's good that it got interrupted actually, because my talk is based on what Shyam Batman sir talked. That is the basis for my presentation. So actually, it is good that it got interrupted. And my talk is purely based on the case laws. It's called the common laws, the decision taken by the court in negligence cases. And I have a question now. What are the two issues in which more than 55% of the cases of medical negligence in India are fought? And the answer is document is the first one, and second is an improper consent. And I'll be dealing with case laws related to these two issues first. So first, I'm not going to talk to you on what a document is, how to keep all those documents, and what consent is. And purely the talk is based on the case laws. And first, we'll be going to documentation part. And there was a case. It happened in Mumbai. A busy practitioner is a pediatrician, a very good practitioner, but unfortunately, one day a 2-year child who was under his treatment died suddenly. But that case came into the court, and the court observed there is a lapse in recording the medical treatment given to that child. And what were the lacunas court observed? The entries made in the case paper and the nursing diary about the treatment is some lacunas were there. The first one is lacuna was doctor had not recorded conclusions of the examination of the patient and medical treatment given at the same place. Now this doctor has having a habit of recording, writing everything in a separate sheet. Once you complete one sheet, he takes automatically goes for other sheets, and there he prescribed the treatment for investigation for another paper, and there is no continuity in that. So the conclusion of the patient examination was also recorded separately, and on that paper there was no time, no date, no name of the patient. So this was his habit actually, even though he is a good pediatrician. Now what the court did, the court constituted an expert committee, and the report of the expert committee came. The usual normal procedure followed by doctors is conclusion of medical examination and prescribing the medicine at the same place, not in different papers or sheets of a book. And this doctor method is found different by the expert committee, and this way of his writing is interpreted as an afterthought after the death of the patient, because it was not in continuous and it was in different purpose. And the committee opined the doctor did not follow the normal procedure of record writing, and it is only an afterthought after the death of the patient. So again, he has a habit of writing as per the order sheet as written overleaf. That also considered as not as a normal procedure. And based on this, the court went against the doctor. And from this case, my suggestion is a record on existing paper or sheet rather than using a fresh one, and maintain continuity in writing medical records. So this is one case law. This happened in Mumbai in 2015. Now, always documentation should be complete. Always it should be contemporaneous. And medical record can be a good friend for the doctor, and at the same time, the record will be an enemy too. There is another case where the anesthetist wrote glycol instead of glycopyrrolate. So when the patient died, the case came to the court, but he could not explain why did he write glycol instead of glycopyrrolate. He said there was a lack of space. So, but the court verdict when it came, it was against the doctor, and one of the comment was use of confusing abbreviations in the medical record is another deficiency of service. So what the suggestion is, whenever you use standard abbreviations, use only standard and non-forms of abbreviations. So there is a tendency of writing pickle for pallor, all those things. So many non-standard forms are used by doctors while writing medical records, which is not a good practice. Then another case, a case of death during surgery has come to the court. During the trial, the deficiency noted by the anesthetist, he had left the column of weight in the pre-anesthetic checkup format, but he knew the weight. he calculated the dose of drug based on the weight, but in the pre-anesthetic check format, that weight was not mentioned. So what was the court opinion? The dose that is usually calculated on the basis of weight of the patient, that could not be calculated by the court. So we could not convince, and the conclusion came that the sudden cardiorespiratory arrest was due to overdose of anesthetic drug administered. So that is the importance of a proper documentation. Here the spaces are left. It should not be like that. So that means precaution should be that do not leave blank spaces in a standardized printed form. The next, over documentation. Recently I have seen a case that in our hospital itself, over documentation after, if something happens after a MISHA, over documentation always is suspicious in the court of law. So never do that. Follow the routine procedure only. Once something happens after a MISHA, never go for over documentation. Never go for a new sheet and writing in a way which is different from the usual practice. So that may turn against you. At least past for availability. But for future, all medical records of indoor patients should be digitalized on regular and continuous basis and kept indefinitely for future references. And for hard copies, they say the government order says OPD records for 3 years and inpatient records also for 3 years, but medico-legal registers and case sheets 10 years or till disposing of ongoing cases in any of the courts related to these records. This is 2015 order from the Ministry of Health and Family Welfare, Government of India. Now, regarding taking of leave by a medical practitioner, there are different case laws. So whenever a patient is on treatment, get the consent of the patient that I am going for, he inform the patient and delegate if a surgery has been done for him, delegate post-operative care, and this has to be taken care of. So inform the patient, delegate post-operative care. These are two important, especially if a surgeon is going on leave after conducting surgery. And this has to be recorded in the case sheet too. So inform the patient for any planned leave valid in advance. Appoint a substitute of equal qualification and experience. So regarding leave, Indian Medical Council Regulation 2002 gives a rule that once having undertaken a case, the physician should not neglect the patient, nor should he withdraw from the case without giving adequate notice to the patient and family. So this is what the IMC Regulation 2002 says. But if a doctor faces a personal emergency, the leave taken by the doctor is valid. That's what the court says in different cases. So he cannot accept a case, or he can refer a case, he can transfer a patient to another doctor or hospital. If the doctor needs an emergency leave, this has been accepted by various courts in India. Then transfer of duty while on leave. This is a case, a pulmonologist had left for outstation when the deceased was still admitted in the hospital and was under his treatment without giving the instruction to another doctor who otherwise was not a qualified specialist in the relevant field, but actually he was a physician. The pulmonologist, after the OP, he left home. The patient was in ICU and he was taken care by a physician. So the patient had some mishap happened. The doctor, the case went to the court, but the court was in favor of the doctor. The court said a doctor could not have been expected to remain with the patient or in the hospital 24 hours a day. Like other normal human being, he also needs to take rest and his meals and then get ready for the duty to be performed on the next day. This is the court verdict in that situation. Therefore, there was no negligence on the part of that pulmonologist in leaving the hospital and the patient being treated by another doctor in his absence. So this is a case law that actually the case was in Rajasthan. Then about transferring of patient, a case law related to transferring of patient, the allegation was the premature baby was at first transferred to a nursing home by a gynecologist, but as no doctor was present, the baby was again referred to another hospital in the next day. The case came to the hospital. The court said, ensure that the requisite consultant and infrastructure is available before referring or transferring a patient to another facility. So ensure a expert and expert plus infrastructure where the doctor is transferring a patient. Then it is mandatory. This is mandatory. Otherwise, it is considered as a negligence. So referring a patient to a place where there is no facility, no expert is per se a negligence. Then another case, the doctor transferring the patient to another hospital is responsible for the patient during transit until the time the patient is accepted by other hospital. So it is the duty of the referring doctor or the hospital to take appropriate precautions and the care of the patient in transit. Doctor must accompany the patient in ambulance during transfer in appropriate cases. So this was also a case law. And there is another allegation when the patient was readmitted for post-surgery complications and referred to PGI Chandigarh after she was kept hospitalized unnecessarily for about 2 weeks. This is another interesting case where the court held that this is negligence. Why this is negligence? Do not admit a patient in the first instance if the requisite facilities and consultants are unavailable in the hospital. So in that case, they kept the patient for a few weeks and then only referred to a tertiary hospital that was considered as a negligence. So in a case, a hospitalized patient moves out of the expertise of the treating doctor or hospital, always transfer the patient to another appropriate facility at the earliest. That is the ideal. So in another case, court observed that referring the patient to a higher center does not amount to negligence if there was no delay. So this is important if there was no delay. So there was an allegation against a gynecologist. Baby was premature and there was possibility of respiratory problem. Hence the baby was referred to a higher center for better management, but it was done within 30 minutes of birth. So the court was in favor of gynecologists because there was no delay in transferring the patient. Court observed that referring the patient to higher center does not amount to negligence if there was no delay. So this is another case law. The patient who had delivered a 32-week-old premature baby, and the allegation was gynecologist was negligent as she had performed cesarean in her nursing home having no neonatal unit. So the case was rejected. It was rejected by the court and the allegation was rejected, and the court said failure to keep a pediatrician present in every case of delivery is not negligence. And nursing homes and maternity homes can perform delivery without having a neonatal unit. However, in critical cases, the patient should be referred to a higher center for delivery. This was the suggestion by the court in that case. And that is regarding transfer of patient. Now consent. Sir was given an excellent view about the consent, and I am giving only 2 case laws related to consent. verify the signature of patient attendant signing the consent form or admission form with their signature on official identification proof. Why this is important? Because everywhere, so if you go to railway station, they ask for identity card, and airport they ask identity card, and many places they ask identity card, but only place where the patient are not asked for identity card is the hospital. Now cases started increasing of forging or and producing. They sign the document, later they say that it is not their signature and it is not their identity. Impersonation all are coming into the medical practice cases also. So take and preserve photocopy of the official identification proof, because instances of patient or attendants signing the consent form or admission form differently and then point out this difference as an instance of negligence to the courts is increasing with each day. So it is ideal to get the identity card, take a copy of the identity card and keep the medical record is a suggestion based on this type of cases. So a perusal of the consent forms also shows discrepancies therein. For the consent obtained, this is another case. For the consent obtained from complainant number 1, it is stated to have been explained in Telugu in one of the consent form, while on other it is stated to have been explained in Hindi. So the patient parties are Telugu. Hindi is not clarified. So ideal thing is to ask for an identity, keep a photostat of the identity card, or that is safer situation. So that is the safer side while treating a patient and while taking consent. Now next is, sir has already mentioned about the importance of CMEs. So this is another case where the suggestion has come as update on drugs banned and read the instructions on drug insert. So there was a case, the complaint was due to wrong treatment and negligence doctors, a lady suffered permanent loss of eyelids, partial loss of eyesight and permanent loss of their glands, along with the financial loss, mental agony. So the case came to the court. And the first question from the court was whether the general practitioner followed prescribed procedure to administer tablet datifloxacin 400 mg to the patient for the disease. And second question was whether the doctor too and the dermatologist followed the standard protocols to treat Stevens-Jones syndrome with progression to toxic epidermolysis. So why this came? Because the patient party produced a copy of the Gazette of India published on November 23, 2011, which says that datifloxacin formulation was completely banned throughout the country from the date of notification. Another document also produced in the court by the same patient party showing that this drug is banned in USA during 2006. And the allegation was rejected because this drug was prescribed in the patient 16/3/2011. When the case came to the court, it was beyond 2011, but the treatment was done before banning of that drug. So suggestion is keep yourself updated on the drugs that are banned by the authorities in the state you practice. Why I mentioned the state you practice in India, the state has the authority to ban a particular drug. So a particular drug permitted in one state could be banned in another also. So keep update yourself on the drugs that are banned by the authorities. This is also important. So another complaint in the same case, doctor recommended the drug without any hypersensitivity test. The patient had alleged that failure of doctor to perform hypersensitivity test before giving the drug was negligence. And the doctor defense was he had followed the instructions written on the drug strip. The small drug strip which is kept along with the drug with the small letters is also important. The doctor's defense was that he had followed the instructions written on the drug strip, that the patient could not produce any medical test to debate doctor's defense. So finally, doctor's defense was accepted by the court. And next one, now there are few cases coming. The type of suture material used by the doctor is improper. Such cases are also increasing in our country. So suggestion is use appropriate type of sutures after taking into account of the relevant factors. So for surgeons, gynecologists, doctors working in the emergency department, they should have a thorough knowledge on what type of suture materials has to be used in a particular situation. So a case came to one hospital with a head injury. The doctor sutured the patient 2 centimeter wound with a 2.0 nylon thick thread and not with a thin thread with the 3 stitches. That was the allegation. So because of that pus formation, it was infected. That was the allegation. But it was rejected by the court. Now next is inform the patient's attendance whenever the time taken for surgery is longer than usual. You know what appendicectomy requires this much of time. Why the doctor has taken 3 hours. Then if something happens, the delay raises suspicion. So always inform the patient's attendance whenever the time taken for the surgery is longer than usual. Next, performing an elective surgery on an emergency basis without any sound justification could be held as negligence. Performing an elective surgery as an emergency one is also negligence. So especially this is important during COVID period, which is elective, which is emergency. Then next is investigation request. Now, if you give an investigation request to a patient, the patient goes outside, he does investigations according to his choice. When something happens, he comes with the investigation result, not with the investigation request, and he says that the doctor has advised only this investigation. So it is always better to keep a copy of the investigation, ideally a carbon copy of the investigation request in the medical record. Same with the outpatient departments, those who are practicing at home, etc. Prescription also, just give a prescription to the patient. He may not buy all the drugs at some time, but the doctor doesn't have a copy of that. So it is ideal to keep a copy of the prescription and also an investigation request, or he can enter in the register. That is a safe thing to defend the litigations. Next is while discharging of the patient, what are the things to be taken care of? If a patient leaves the hospital without a valid discharge, send a written intimation to the nearest police station. Premature discharge of patient is considered as negligence by the court of law. And in front of the court, there is no concept of discharge on a request. Next, attacks on doctors and hospitals. So recently, all associations of doctors are requesting for special laws for protection of their life, protection of doctors, protection of hospital, etc. So the Ministry of Health and Family Welfare prepared a very good bill that was sent for approval of the Home Department a draft is prepared, which was sent to the Home Department, but the Home Department did not approve, saying that only a particular provision, for a particular provision, a separate law is not ideal, and they rejected the proposal draft of the Health and Family Welfare Department. But we have enough laws to protect the hospital and doctors in the Indian Penal Code sections itself. So I'll be discussing those sections. Misbehavior with the dirty doctors, nurses, ward boys, and other staffs, and use of abusive language can be charged under section 504 of Indian Penal Code. That is intentional insult with intent to provoke, breach of peace attracts punishment of 2 years with fine or with both. It is bailable, non-cognizable, and compoundable. Another section is threatening duty doctor can be filed under section 506 of Indian Penal Code. That is punishment for criminal intimidation, 2 years imprisonment with fine or with both. It is bailable, non-cognizable, and compoundable. Another one, attack on duty doctor, IPC 332 and 333. What is 332? It is voluntarily causing hurt, and 333 grievous hurt to deter public servant from his duty, and it attracts punishment for 3 years imprisonment or with fine or with both, and 333 10 years fine, and it is both non-bailable and cognizable. The next is damage to hospital property can be charged under section 427 of Indian Penal Code, which carries 2 years imprisonment or fine or both, which is bailable, non-cognizable, and compoundable. So there is another 2 more sections are there. Forceful entry into hospital, Indian Penal Code sections 141 and 43 can be charged for an unlawful assembly, which carries 6 months imprisonment, fine or both, which is also bailable and cognizable. So even though there is no separate law for protection of hospitals and the doctors, these sections of IPCs can be used. Now, it is MCCD. This is a problem which occurs everywhere, mostly in the emergency department, casualties, etc. Just a brief description on the medical certificate of cause of death. There is a form number 4 for hospital inpatients, and there is a form number 4A, which is for non-institutional deaths. And there are so many queries from various parts of doctors that if they declare death at home, can they issue a certification of, say, the certificate of cause of death. So my suggestion is, if the doctor is confident in filling this part, he can issue a certificate, otherwise it is at his risk. I hereby certify that the deceased dash is a resident of this place, was under treatment from this date to this date, and he died on such and such date. And if the doctor is confident to say this part, he can issue a certificate even if the death occurs at home or some other places. So this is non-institutional certificate for non-institutional death. And this part is the writing of cause of death. A, B, C are there. So actually this I prepared for general practitioners. So I am showing an example. A male aged about 45 years came to hospital with history of abdominal pain. On examination, it was diagnosed as peptic ulcer, and he was suffering from hypertension and diabetes mellitus. On 3rd day of hospitalization, he developed symptoms of suggestive of peritonitis due to duodenal perforation and subsequently died. So it's suggestive of peritonitis due to duodenal perforation. So always A is what? Peritonitis. B is duodenal perforation. So there is a trend of writing cardiac arrest, trend of writing cardiorespiratory arrest that has to be avoided, and the cause of death in this case. So any cause, any death, the mechanism is cardiac arrest or cardiorespiratory arrest, and this is the ideal way of writing a medical certification of cause of death. So A is peritonitis due to perforation of peptic ulcer. Now, why this is important? There are case laws. Issue death certificate only when absolutely sure about the cause of death. Otherwise, it could be held as negligence by the court and could also invite criminal prosecution. This is a case law. Then another case law which happened in Kerala, Sumasarasan versus Kim's, death certificate must record both the immediate cause of death and the antecedent cause. Then another case law says provisional diagnosis or differential diagnosis need not be documented in the death certificate. This is another case law. And issue death certificate only when sure about the immediate or antecedent cause of death. Otherwise, refer the dead body for post-mortem. That is another case. Do not issue death certificate merely because you have attended the patient before death. Do so only if you are sure about the cause of death. So this is the importance of issuing of medical certification, and certification of cause of death is very important in front of law also. And for statistics preparation by the government is also it is important. Instead of writing just cardiac arrest and cardiorespiratory arrest, there is an ideal way of writing cause of this certificate. Now, next one. This is a recent case. This is a recent case. This is actually a face of a deceased person. Face of a deceased person. So there is so whenever a death occurs in a hospital, there is dead body dressing. One nursing assistant or somebody else in the hospital does the dead body dressing. So while he's shaving, accidentally there he made an aberrated condition, whatever it say, but it looks yellow. It's a post-mortem injury. But this injury occurred accidentally, but by the physician assistant's mistake. And what happened during funeral, everyone noticed this injury, and the relatives or the relatives, they created an issue saying that there is a disfigurement of the face of the deceased person from the hospital, and they were about to file a case in a court of law, but it was settled outside. And the issue, if it is coming to the court, it can be charged under 297 of Indian Penal Code, that is indignity to any human dead body, invites imprisonment of 1 year or fine or both. And there is a case law too. The duty to perform the standard of care continues even with the dead body of the deceased patient. And there is a case law too. So this is court direction. The duty to perform the standard of care continues even with the dead body of the deceased patient. With this, I am completing my talk with these 2 points. Law in India clearly stipulates that it is for the patient to prove his or her allegations in the court, and in case where there is any doubt, the benefit of doubt always given to the doctor. Thank you.
Shall we sum up, sir? Shall we sum up? Thank you, Padma Umar, for this wonderful presentation. And you have highlighted almost 12 different case scenarios in medical negligence suits. The first one was about different types of documentation and how improper documentation can lead on to negligence suits. The first one where the doctor has to do continuously, where the details about the patient, there should be the prescription and there should be the advice, and not on a separate paper. And if some improper action or improper method of recording a scene, it would be viewed as an afterthought. Once the negligence occurred, the doctor's afterthought has resulted in such an entry. That was the opinion, or that was the judgment given. And in the anesthetic checkup, if we may think that it is only a very minor thing, that is the weight of the patient was not recorded in the anesthetic record, and the court viewed that without knowing the weight of the patient, how the dose can be calculated, and it was judgment came that it is due to overdosage of anesthetic drugs, since the weight of the patient was not there. And similarly, non-documentation and over-documentation is also equally important, that can lead on to negligence suits. Then about the consent of the patient, and it can be delegated. The post of care should be delegated to the patient, and the patient's consent should be taken before the doctor ends his duty or his temporarily out of or not giving service to the patient. Patient should be properly informed, and he should be delegated or entrusted with a competent doctor who is capable of giving enough care to the patient before leaving from his duty. And while transferring the patient, he highlighted the points that the doctor who is referring the patient should ensure that enough facilities are available in the referring center or the higher center, and the experts are also available. And similarly, the second hospital should have the facility and the expert that should be ensured by the second hospital. Only then they can take up that patient. Do not admit a patient without having those facilities. And during transit period, it is the duty of the referring doctor to ensure that it is safely done. Transfer the patient is being safely done, and there should be a competent person accompanying the patient in the ambulance or whatever it is. And once he reaches the hospital, then it becomes the duty of the second hospital. And if there is no delay in properly referring the patient, it will not be held as a negligent action on the part of the doctor. No delay. That means reference should be done then and there itself. Once the doctor is convinced that reference is needed and are not competent enough to handle that situation. And next, he mentioned about taking the signature and verifying the signature of the patient or the relatives who is giving consent. And it is always better to have a copy of the identification proof or a valid. Wherever we go, in any of the offices or any railway station or wherever we go, we are supposed to show our ID card. And similarly, in the hospitals should also make sure that they have an identity copy of an identity proof of each and every patient. Now, I think many of the hospitals have started that. And then he talked about the drug ban. The doctor should be updated with the available drugs in the market, whether it is a banned drug or not, or if banning comes on a particular drug, that should also be aware of. And at that on that particular type. And in one particular case, it was the case was judged in favor of the doctor, since the ban came later only. Then he highlighted the importance of choosing the right suture materials, the warning for so general surgeons, obstetricians, or any of the surgeons. Then if the doctors are taking longer time for surgeries, that should be properly informed to the attendants. And elective surgery is doing as an emergency measure, and emergency surgeries are being done as an elective procedure. Both can be considered as negligence. So elective surgeries should be done as electives, and emergency surgeries should be done as emergency surgeries only. Then while for doctors who are working in a hospital, anyway in the hospital there will be a medical record and office copy of everything would be there. For doctors who are working in OPDs or doing practice in the hospitals or their private small clinics, they should also keep a record of the prescriptions given and the investigations request given, or whatever paper go out of your hand should have another copy with you for future reference, and that can be put forward as a defensive. Then while discharging the patient, certain points he highlighted. While an absconding patient, it should be intimated to the police, and early discharge is considered as a negligence. And unless the patient is fit enough to be discharged, patient should not be discharged. And there is no concept called discharge against medical advice or on request. Discharge on request, not against medical advice. Discharge on request. When patient requests for a discharge, you are not supposed to discharge that patient. I think for instead of discharge on request, it would be safe for the doctors to write it as discharge against medical advice to defend our case. And then he highlighted certain points about this, whether topics discussed in the as case scenarios. And then he handled the two more topics. One, attack against hospitals, and one medical certificate as to cause of death. Attack on doctors in hospitals, there are about 5 situations where like misbehavior towards the hospitals, or threatening the duty doctor, or attacking the doctor, or damaging the hospital, and forceful entry into the hospital. These 5 things were mentioned, and the punishments were also mentioned, and we highlighted the importance of writing the cause of death properly in the MCCD certificate in the proper way. The immediate cause of death and the antecedent cause of death should be known thoroughly by the doctor, and only then you can issue a death certificate. Otherwise, you can keep the body for post-mortem examination or further formalities to be completed, and never ever certify a cause of death as cardiopulmonary arrest or cardiac arrest, because in each and every case that is the final event happening. So it is always better to do in the proper way, and those were the things mentioned. And issue that certificate only if the person is very sure, doctor is very sure about the immediate cause or antecedent cause. And this were the things Padma is mentioned, and we can request questions from the participants.
I'll just add one thing regarding that hospital attack. Doctor, can you hear me?
Yes, sir. Padma?
Okay. Regarding the hospital attack case, you said you can take recourse to IPC. Absolutely correct. But we have our Kerala Act also in place.
Yes.
That makes it cognizable and non-bailable. Yes. I mentioned only about hospital attack. The full name of it is Act 14 of 2012. The Healthcare Service Persons and Healthcare Service Institutions Prevention of Violence and Damage to Property of 2012. That's a very strong act.
Yes, sir. It is there but not for all the states. Few states.
No. The central enactment didn't go through, but we have different states, including Kerala. Which is one state act, because it's in the concurrent list. The states can make enactment.
IMA has asked for a national one.
That might take some time. I have one doubt. You said that there is no concept of discharge on request, but to a certain extent, Dr. Geeta has clarified about LAMA, that is against medical advice. Why do you say that there is no concept of discharge on request?
So it's a part of court judgment in one case.
Which court?
Which I read. I don't remember the name of the case.
I don't know, but it doesn't appear to be fully correct, because my right of self-determination cannot be dictated. I don't want to be treated by you. I want, of course, the terminology may differ. The initial thing is I request. Then the might be against medical advice.
Then it comes under discharge against medical advice, and
a discharge against medical advice starts from a request from the part of the party to get himself discharged. No,
we cannot write discharged on request.
I understand. Thank you, Doctor. Wonderful presentation. Regarding that ID proof thing, that we have requested almost all hospitals to implement, but it's not very practical. For example, in one of the major hospitals, I have requested that a dedicated staff should be there for taking consent. Otherwise, it usually is given to some person who does not know the significance of taking consent, and on the run, some signature or scribbling is received, and later when it comes to a real issue, then you will be taken to task. It's always advisable to have a dedicated staff and team for these things.
Sir, is it not that the treating doctor should be taking the consent rather than a dedicated person taking consent for all?
Don't take me amiss. The consent has to be, the explanation has to be given by the doctor. That's the mandate. There is, what I'm saying is that the doctor cannot take the paper and run around to get the signature. For that,
correct.
Let there be a dedicated staff.
Okay.
It's in paper, and no doctor, we all know that explains all the procedure and it's being done elsewhere. But the law mandates that the doctor should explain. But end of the day, like we earlier said, Padma sir also was earlier, productive, what was that? Consent. You asked a terminology earlier. informed consent, and the last one you asked was consent used of something does not be used. That is when you ask me the question regarding consent used term, that means that end of the day, what matters is not who explains, what explains, etc. Can you establish that the patient or the patient party fully was aware of what they were consenting to or refused?
That is more important.
Sir, is it audible?
Yes, sir. Yes.
It's audible.
Is it better to the doctor should sign the form, or the doctor also should sign the consent form?
Yes, it is always advisable, and it is almost all the forms contain that the whoever is the treating doctor should sign. But I'm not very sure if it's a legal mandate, but that is the way it is being taken.
There is a case law. They suggest. There is a case law. The court suggested the better to sign the doctor also.
The consent aspect is fully discussed and elaborated in Samira Kohli's case, wherein consent for one procedure cannot be extended to other. It should be a what we call real consent. The term used is real consent because it's not mere consent. Real consent. The stakeholders should know what they are consenting to. It is just like a contract. You should know what you are entering into.
Sir, I have a question to Champatman sir.
Yes.
Is it possible for a patient or relative to file a case as civil negligence case and criminal negligence case simultaneously?
Absolutely, both are different. One is they only initiate the criminal case. Is the state is the aggrieved party, not the party. As you know, like all prosecution is the APP or the public prosecutor conducts. The other is for redressal of his personal grievance to get damages or punish otherwise. Both are different and distinct.
Okay. Among the negligence cases, what percentage or approximately what percentage of the cases go as criminal negligence suit, sir?
Nowadays, almost all cases start off as a criminal case because that is being used as a means of getting the documents, etc., from the hospital. So, if something goes wrong, initially they run to the police station and see to that a case is filed. So, the police comes, takes, and it is very easy to get those records and things to the police, it seems like. But, end of the day, I believe that more cases are initiated as a criminal case, but prosecuted not much. But civil cases, once initiated, they usually go to the natural culmination.
So we have 5 more minutes, sir. Rajaram sir, over to Rajaram sir.
Yes.
And Shivashankar Pillai sir.
Okay, one thing.
Pardon? Are you able to hear me?
Yes, sir.
What do you want?
No, sir. To conclude or to give a concluding remark, only 5 minutes left, sir.
I may say that.
Okay, one remark. Gita, one thing that Dr. Advocate Shyam and Dr. Patwar have given an excellent informative talk. It was very interesting. Because another thing I understand from the situations that many of the problems occurs due to lack of communication. Lack of communication.
I would say primary reason.
Yes.
Because
another thing, but when
what you find is that the patient might be your 50th patient or 52nd patient for the day. But as far as the patient is concerned, he is seeing you for the first time. He expects a patient, he expects a proper communication, all those things which you might do unknowingly if you feel slighted. And adding to that, something does not work properly, you got a definite litigation at hand.
Definitely, I have an experience because when I was taking casualty duty, there were 15 casualties was brought in a mass accident. And in one case, one injury certificate, I just forgot. I just error to write at the time of examination. Come to the court, the advocate asked me, in this case, you didn't write the time of examination of this particular patient. And I said, Your Honor, it was a mass casualty, just an error. Yes, I did. Yes, no, it's not. But no, but the court judge interfered, just take it like that. And another thing, now the unnecessary involvement by doctors, other doctors, probably may not be, because when myself and Rajaram were house surgeons, we are not taught, we don't have any experience to how to face a death. When a patient is gasping, the boss will ask us, we will go have coffee and come back. Then the sister will make everything. That sort of teaching was there at that time. Not taught to how to face a death. I think that's also very important because the juniors should be taught how to face a death, how to tackle a death like that. Unnecessary involvement is mainly due to this because they don't know what to reveal to the bystanders. They will do a lot of things. We have done all these things, and even then we could not save the patient.
Absolutely correct, doctor. The stark realities and the lack of proper training and exposure to these things is one of the reasons why this medical legal action litigation is increasing.
Okay, thank you.
So the concluding part, both the sessions were very good and informative, and I am very thankful for the presenters, Advocate Shyam Patman and Advocate Padma Kumar, and also the chairperson, Geeta. So thank you everybody for attending, even though the numbers went up to 18. Now it is only 9. The number is, as I told you, Geeta, even if it is 5 people, we will conduct.
It is a very motivating remark, sir.
See, so many persons came. I don't know who are they. Mostly women, and they disappeared. And one person wrote a SMS to you that your voice is not clear. Smita, her name is Smita.
Smita, my
I don't
colleague.
know.
My colleague.
Your colleague.
Yes,
Okay.
sir.
Okay, thank you for the participation and cooperation, and thanks a lot to Advocate Shyam Patman. Okay.
Thank
Sir,
you.
shall we hear something from Pillai, sir?
Thank you so much. Thank you so much, the speakers.
Sir, one word from Pillai, sir. Sir, please. Pillai,
Yes,
sir.
yes. Thank you for the opportunity. At the end of the day, communication, consent, and proper documentation. If we are doing it well, we can succeed everything. Thank you so much for the opportunity. It is an excellent effort, and I thank everyone.
And if I may add one word, the way in which the both presentations were encapsulated by Dr. Geeta, I think it's something wonderful. Even I could remember what I
Yes,
said.
yes. Very
Great.
good. Very good.
Thank you.
Wonderful. Yes,
Thank you,
yes.
sir.
That was a
Because
wonderful
he was
thing.
able to recapitulate everything.
Correct.
Very
As I
nice.
said,
Very
Thank
nice.
you.
memory
Good.
Now,
is
Excellent.
excellent.
noting.
Anyway, that is a wonderful, wonderful thing. In fact, I mean, I was surprised. I never knew that I spoke so many points in my presentation. But when you put it, I felt I am somebody intelligent.
Thank you.
Thank you.
Okay,
Thank
sir.
you.
Thank you.
Thank you.
Thank you. Have a nice day. Thank you.